This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, so call in your questions on anything from medical malpractice, car accidents. The 31 Law Call number, 256-536-0077. You can also text a question, so you can call it and be live on the air and tell us what your problem is, or you can text us to that same number and we will pull some out. You can also email questions. You can email a question any day of the week on any legal topic. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out. We will have some of your email questions tonight. Michael Timberlake's here from Timberlake, League and Brooks. Good to have you here.
It's great to be here.
Rain coming, wash away the pollen. That's what we're talking about.
Please, no more pollen.
No more
more
pollen.
pollen.
So while we get some of your calls locked in, we like to let you make the law call. We pull a video off of YouTube, and we've got this one. You know, trees and tree trimming, it can go too far. Generally, trees just want to be left alone, but you mess with one and it may just push back. If you're the one that's on the ladder, if that's you trimming your own tree, let's talk about whether your medical injuries are covered by any kind of insurance. Is your health insurance going to cover it? Is your homeowner's insurance policy? Okay, on the other hand, if that's somebody you hired and they came and they're cutting stuff on your property, are you going to get sued over their medical bills? We understand that this guy was not that damaged, thank goodness. Well, but it looks bad.
He did fall with a chainsaw.
That's not good either.
Well, you know, basically the concept is if he is working on the job, you know, he's going to be covered potentially under workers' compensation insurance, as long as his employer has more than 5 people. So his injuries are going to be picked up by workers' comp. Then you look at the homeowner. You say, okay, well, has the homeowner got any responsibility to him? And typically the answer in these situations is no. The homeowner's only got an obligation to tell him about dangers that they know about that the other person may not know about. So you're looking at a tree, they've got a chainsaw, he's on a tall ladder. These are all things that, you know, that guy, the worker on the property created. So the homeowner pretty much is not going to have any responsibility towards that.
Thank goodness.
Worker.
Let's talk.
Yeah, but you always want to hire licensed and insured.
When somebody's coming to your house, you ask.
Absolutely, because if this limb had not fallen on the worker but fallen on your car or your house or your neighbor's house, then they're going to look, you know, that can be a different story.
Okay. We've got text messages coming in.
All right,
we want to talk a little bit about travel. So a lot of people are going to be traveling for the holidays, and if they travel out of state, they have some kind of an accident out of state, which laws are going to apply? And then if there were a trial, are they going to have to go back to that other state for a trial?
Yeah.
And where do you hire a lawyer?
Well, I mean, you know, so you've basically got jurisdiction where the accident occurred. But if it's somebody that 2 people from different states, then you can potentially file the claim in federal court where you reside if it's a business that does business in that state. So you get hit by a commercial carrier in South Carolina, you could potentially file that case in Alabama. But if you get hit by a South Carolina resident in South Carolina, even and you're a resident of Alabama, more than likely you're going to have to file it in South Carolina. You could file it in state or federal court, but more than likely you're going to have to go back there and do that.
Deal with it.
Yeah.
Okay, texts are coming in.
Sure.
Wayne wants to know, it's a question about a drainage ditch. His city is not maintaining the drainage ditch and has been flooding for years. What can he do? Yeah,
waterways are difficult. I mean, you know, if you you know, obviously the city's not doing it. You want to, get video evidence of it. Go talk to your county commissioners. Go talk to the mayor. Typically, you know, I mean, the people that make the decision are the people that you're going to want to talk to. The people in the city council or the mayor. You know, those are the people that you need to say, hey, I can't get any response from the city to do this. Otherwise, you're in a situation where you're looking towards filing an injunction to require the city to come out and do something to remedy the nuisance or the problem that's on your property. And even if it's water, it can be a trespass. So there's legal theories that you can use to get the city to fix it, but of course that's going to be on your responsibility.
We've got Jane on the line with a question from Hazel Green. Hi, Jane. Thanks for calling in. What's your question tonight? Hey, Jane. Hey, Jane from Hazel Green.
Oh, are you talking to me, Jane?
Yeah, Jane.
Yes,
how are you?
Hello. How are you? What's your question tonight? Thanks for calling.
Oh, thank you so very much for taking my call.
Sure.
I thank y'all guys very, very much.
Thank you.
Y'all are very informative.
Excellent. We learn things sometimes too. What can we answer for you tonight?
Okay, yes, ma'am. My question is, I haven't worked in over like 25, 26 years.
Okay.
And and I've got COPD and other health conditions. And in order for me to file for my disability, my sister says that the Social Security thing says I need 2 points, and I don't know what that means. But my husband also, I think this is something for Tom, has Social Security. He's on Social Security disability, turned 65 this year, and so it will switch over to his social, just regular Social Security. So my question is, should I work for those 2 points, or should I wait and just draw off of him when I'm turned 62, or either wait until I turn 65? But the thing is, we've been together almost 35 years.
Right. Yeah, just simply because you're married doesn't necessarily mean that you're going to qualify to get any earlier benefits or any additional benefits from your husband unless he should pass away. But in the situation you're talking about, you have to, in order to qualify for Social Security disability, you have to work a certain number of quarters in the last 2 years. So you're going to have to continue, you either have to get back in the workforce to do that, or in order to qualify for Social Security disability. You can, file for early retirement at age 62. It is a reduced benefit, but if that's what you need to do, that's also an option. But if you don't qualify for Social Security disability, you may potentially qualify for what we call SSI, which is basically disability for people that have not worked or do not qualify for disability. SSI is a reduced benefit, so you may want to look into that option as well. But it's you've got a number of choices out there.
We got this text message in. What can be done when an ex-husband steals a pet horse? I paid for him myself. I cared for him and took care of him. When the divorce happened, he promised me that the horse could stay at his house until I got a place, until I got land for him. And as soon as I'd let him know, at that time, I could have the horse back. Well, he's not giving the horse back. I have paperwork on the horse, but I left it in the ex-husband's house, locked in his safe. So in divorce and custody, this is a custody issue.
This is right up your alley.
Animals are in Alabama seen to be as property. So if you had this paper that told whose name the horse was registered in and those kind of things, that would be very helpful to taking it back to a judge and saying this was not decided by the judge. But animals are treated as property, and so trying to argue about custody of a horse, or if you didn't get it put in the divorce paperwork that you did, or you didn't reserve that issue, it becomes really difficult, not just for horses or pets, but for other things. If you didn't put it in there and be very specific about it, going back in front of a judge and getting them to care about who ought to have the horse after a period of time is extremely difficult to do.
Yeah, I mean, the judge is going to look, and that's why it's important during a divorce proceeding that you identify all the marital property that you contend is marital property. And some people fight over what is marital property, and I brought this into the marriage and didn't use it for our benefit or whatever. It may not be categorized as marital property, but if it's not in the divorce decree, it becomes difficult.
If it's something that was listed, so sometimes the divorce will say she gets to keep everything that she owned before the marriage, right, and all of these other things. So if she had owned this horse before the marriage, you could take it back and you could say he's in contempt because he's not giving you something that is clearly laid out in the divorce.
Right.
We've got Howie on the line with a question from Huntsville. Hi, Howie, thanks for calling. What's your question tonight?
Yeah, I have a question about a divorce matter. I purchased a house at a sheriff's sale that had been the sheriff had sold for failure to pay homeowners dues, association dues. The property had been purchased by the husband before they got married, was always only deeded in the husband's name, and they got a divorce, and in the settlement agreement, they agreed to let the ex-wife stay in the house as long as she paid the mortgage and paid the repairs and the homeowner's dues, and that they would be, in good faith, put the house up for sale and split the proceeds 50%, 50-50. In the meantime, the attorney for the ex-wife filed a list pendants here in Madison County, naming the husband and the property. And in addition, the attorney filed an attorney's lien against the property in the name of just the ex-wife for her half of the attorney's fees for her half of the money coming from the sale of property. Well, now I'm trying to sell the house, and the attorney for the attorney with the attorney's lien is claiming that I have to pay out of the half of the proceeds for her attorney's lien. Now, I want to find out, since it was sold in the open market to me at the sheriff's sale, and it was an arm's length negotiation for value, why do I have to pay for her lien?
Very interesting.
Yeah, I mean, you're dealing, it's a pretty fact-specific situation you're dealing with there, Howie. But if you buy property, right, that is subject to a lien, it's subject to something that occurred before you actually became the owner of the property, then you're buying that property subject to that lien. So if it was a judgment lien, if it was an attorney's lien, if it was any kind of mortgage that was on the property, simply because you're buying the property doesn't mean that you're buying it free and clear, that you have clear title. You're just buying whatever the interest is that they're selling at that point in time. So you can buy it subject to those to those liens, and that's something that you'd have to look into, specifically what the priorities were. But I think you're probably, these people are in line before you are in terms of the property.
We're going to take a break. We'll be right back. It's Ask Us Anything night, so stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Michael Timberlake's here from Timberlake, League & Brooks. They are personal injury attorneys, so they specialize in cases with car accidents and medical mistakes and nursing home negligence and all those kind of things. We've got Henry on the line with a question from Huntsville. Henry, I think you've got a question about doing a will.
Yes, hi. I was wondering, I moved down here to Huntsville from Northern Virginia about 10 years ago. I did have a will up there, but I was wondering, since I bought a new home here in Huntsville, is that my new home is included to my will, or should I make a new one?
Yeah, that's a really good question. Basically the short answer is, if your will in Virginia would include all of your property that you have, then you may not necessarily need to get a new will in Alabama. We're gonna be able to probate that will here. You want to make sure that it's a valid will in Virginia, and if it's valid there, then it would be valid here. But at the same time, when you've had a big life change like this, you've moved somewhere, it's a good time to take the opportunity to update your documents. Everybody needs a will to dispose of their property. They need a power of attorney to allow somebody else to make decisions for them, if they, in the event that they can't make decisions for themselves. They need a health care power of attorney that gives somebody the authorization to make health care decisions for you, and they need a advanced directive, which basically says what you want for health care if you should not be able to make your own health care decisions. Those are all documents that are relatively easy to get and not incredibly expensive for a simple estate in Alabama. So, it's one of those things you want to go ahead and do it while you have the opportunity, and in case something should happen.
Yeah, we're glad that you're living here and you've been here for a while. You like it?
Here, yeah.
Good. We've got Tony on the line with a question from Athens. Hi, Tony. Thanks for calling. What's your question tonight?
Hey, Sharon. How are you?
I'm good. How are you doing tonight?
Well, I'm so-so. I had a question about how hard and how should I go about filing for a theft by deception case? Because, I had somebody kind of took advantage of me. Of course, I'm retired now.
Okay.
So, and I got her vehicle. Not necessarily her, but her truck broke down, and she had got 3 little kids. And I said I'd get her something till she could find something, and then her sister takes me back a few days later, and she said, I thought she'd changed. She does this for a living. I'm sorry to tell you now, because me and her's pretty close, too. So I was wondering, what do I need? How do I need to get started on that? What do I need?
So you gave this person a vehicle, and there's no paperwork. Is that kind of what we're hearing?
Well, the paperwork, I'm having a hard time hearing you.
Sure. You gave this person a vehicle, and there's no paperwork, or is there?
There's, she went and got it. She went up there and got it. I signed the check, and she went and got it.
Okay.
Gotcha. It's one of those situations. If it's a criminal, if you think it's a crime, and they stole something from you, then you can contact the district attorney's office. If it was just a matter where they took something that was yours, or didn't fulfill their obligation to pay you when they said they were going to pay you, then that's a civil matter, and you'd have to look into the civil court. If it's less than $5,000, you can file an action in small claims court. You don't need a lawyer to represent you, and you basically say, look, we had a deal that I was going to sell her this car, or we had this agreement, and then she didn't fulfill the deal, and she's, I'm out that amount of money. If it's over $5,000 and you're looking at, district court or circuit court, and you're probably going to need a lawyer to represent you in that kind of situation.
Got a text message in. Somebody has got 2 children from a previous relationship, and since then she's gotten married. She has not heard from the children's father in 6 years. He's not helped support the children, and her husband would like to adopt the children. So what's the process?
So what is the process there? So there hasn't been, they can adopt if the other person has given up their voluntary surrendered their parental rights, or the court has terminated parental rights. But absent that, what can be done?
So if you drew up paperwork, the question is, would the father sign off on something? Would he consent to the adoption? So it might be that he would consent to the adoption. He's not seemingly got any interest in the children and has not been supporting the children, so maybe he would sign off on something and agree to it. But if he's not going to sign anything and agree to it, you're going to have to go through the steps and the process of terminating his parental rights, and that's going to require going to juvenile court to get that done before you can even get heard in the probate court these days. So they've changed the law a little bit recently, but it sounds like something. He's abandoned the child. There's a number of things that the juvenile court would probably agree to in terminating his parental rights, but it's going to be a little bit of a fight.
Yeah, I mean, what if he's served and he just doesn't show up? Hadn't paid child support, doesn't want to be involved.
So they're lately requiring you to file something in juvenile court to go through that whole process, and you would have to put some things on the record, even in juvenile court, to get his rights terminated before you take it to the adoption in probate court. So we're talking a little bit about summertime things with like pools. Folks are getting their pools set back up, and it's very attractive. But you worry about somebody getting injured in your pool. If you've got one, what do you need to be worried about?
Yeah, I mean, the basic things that most people know before they get a pool. Pool has to be in an enclosed area in a backyard. The fence has to be present, and it has to work. So if you're upgrading your pool, you're getting water clean, you're doing those types of things, check out your fence. Make sure that it's up to speed, and that people aren't and there's not a hole in the fence, or there's not some way that people have been getting into the fence, and so you want to make sure that it's doing its job. You also want to make sure that the areas around the pool are all safe, and that any pool equipment or whatever is not hazardous in that situation. So just do your due diligence, have fun, but do it safely.
Got in a text question. I was injured in a car accident that left me in the hospital for several months. I tried to hire several lawyers, but they refused to take the case. What can I do? Okay, so when somebody's been injured and they're trying to hire a lawyer,
right,
why might the lawyers not be interested in taking the case?
You know, I mean, so lawyers take, lawyers that do what we do, they take cases on a contingency fee basis, which means that we do not get paid unless there is a recovery. So in a situation where we're looking at a case, one of the considerations is, what is the strength of the case? It doesn't, we don't, make, the case doesn't have to be a slam dunk in order for us to get involved and take it. But if we think that there is a low likelihood of being successful in the case, just based on the facts of the case, then it may be a case that we would turn down. If it is a case where we think that there's not a possibility of recovery because there's not insurance, that's more than likely a case that we're probably going to turn down. Or if we get in a situation where our client is involved in the wreck and contributed to the wreck. Alabama's pure contributory negligence state. So if you contribute or cause your own injuries, then it's an absolute ban on recovery. So those are kind of the situations where we look at it and say, look, if there's not any insurance, if you're potentially liable, if there's no way to recover, those are things that we're going to look at on the front end and say, there's no way to help you.
We've got Michael on the line with a question from Higdon. Hi, Michael. Thanks for calling. What's your question tonight?
Yes, I worked 16 hours today.
Okay.
And
just listen.
And my boss did not pay me not one red penny. What can I do?
Okay.
Well, I mean, it's basically fraud. It's basically, a situation where you've agreed to do this for them and they're not paying you. So it's, there are laws on the books for the Fair Labor Standards Act that say if you work, you're entitled to at least minimum wage, and that you're entitled to be paid within a reasonable time that you did the work. So the question is, what is a reasonable time in this situation? When is he going to pay you? If he does pay you within a certain time of you performing the work, then he could comply with the law.
We're going to take a break. Be right back answering more of your questions. Stay with us. If you haven't gotten your questions answered tonight, here's how to get in touch with Michael Timberlake with Timberlake, League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way. And I do family law.
Sharon does family law here in Huntsville, 256-539-7337. She is very helpful, and she was able to answer our adoption question tonight that I wouldn't have been able to answer.
Thank you so much. Okay, if you own, got a text, if you own property that connects to state or county highway, can you refuse to allow individuals to place their permanent signs and advertising in the right-of-way between your property and the highway?
Typically, it's not legal for anybody to place signs in the city or the county's right-of-way. They do it all the time.
Yeah.
But typically, there's either an ordinance that says it's not, it's owned by the county or the city. It's not public property in the sense that everybody has access to it. So you can take care of the signs and throw them in the trash.
Good luck. Thanks for all your questions tonight, and we'll see you next week.